Titi, thank you so much for joining.
Thank you. It's my pleasure to be here.
So do you want to just give the viewers a quick rundown on who you are and then we can get into talking about IP?
Okay, thank you so much for the kind invitation and for your excellent work. My name is Titilayo Adebola. I'm a lecturer in law at the University of Aberdeen. My areas of specialization are in international economic law and intellectual property law. The sectors I focus on primarily are food, agriculture, and the environment. I am an editor in economics law, as we know, and I also work with other networks such as the Commercial Law Research Network of Nigeria, Flora IP, and the IEL Collective.
Perfect, thanks. Oh, here, hi.
Hi.
Hi, thanks for joining us. Sorry, we had lost you earlier.
I know network issues, but hopefully yes, they come back now.
No problem. Thanks for joining us. Do you want to just give us a quick intro on yourself?
Okay, yeah. So my name is Ohioche. For short, people call me Ohio or Ohio. Um, it has no connections with the United States. Um, and so I'm a lecturer at the Montfort University in Leicester, based here in the United Kingdom. Um, I grew up in Nigeria, did my first degree there. Then I lectured for a short while in a Nigerian university, the Asian city of Benin. And then I moved over to the United Kingdom to do a master at the University of Hull. And afterwards, I did a PhD at the University of Liverpool. And I've been teaching at the Montfort University in Leicester for 4 years now, about. And yes, I'm an editor of economics law blog. And it's a pleasure to be on your show.
Well, I'm really excited to have you both, and thank you as well for all the fantastic work that you're all doing with the articles. I'm definitely a big fan and trying to get people to subscribe. So thanks again. Okay, so the first thing we're going to talk about actually was we're going to go into IP and just talk about the state of intellectual property in Africa. So do you want to kick us off, Titi?
Thank you so much, Muloongo. So I'll just start by saying that the intellectual property rights architecture in Africa is fragmented. That means that we have a variety of institutions, of legal systems, legal norms, and practices around the country, around the continent. So we would say that the two main intellectual property institutions are the African Intellectual Property Organization, that's OAPI, and it focuses mainly on Francophone Africa, that is the French-speaking part of Africa. It has 17 members. It was established in 1977 through the Bangui Agreement and entered into force in 1982. We also have the African Regional Intellectual Property Organization, ARIPO. It focuses mainly on the Anglophone or English-speaking part of Africa, and it has 19 members. It entered into force through the Lusaka Agreement of 1978, which was established to the Lusaka Agreement of 1978, entered into force of 1976, entered into force in 1978. So the difference between both organizations is that the OAP has a uniform system. So that means that it has a centralized system of administration, regulation of intellectual property systems around all its member states. On the other hand, ARIPO has an open system where members can join any of the protocols that they decide to ratify. So the difference or the tensions between both are that there are different provisions covering the different categories of intellectual property. So, for example, let's take OAP. OAP has provisions on plant breeders' rights, and it's also a member of the International Convention for the Protection of New Varieties of Plants. On the other hand, ARIPO is not a member of UPOV, that's the International Convention for Protection of New Varieties of Plants. It has an Arusha Protocol, which is a draft protocol for plant breeders' rights, but that is different from OAP's protocol on plant breeders. So you see that tension where you have two organizations and two different types of systems covering one subject matter. Now we have a move on the continent towards harmonization or coordination of intellectual property rights. One question that would arise from that would be what type of system would then prevail? Would it be the system that is set out under OAPI or the system set out under ARIPO? And so the questions that we have then would also tie into the further harmonization and integration of our economies on the continents under the African Continental Free Trade Area agreement that we are negotiating now. We have that under phase 2. So under phase 2 of the AFCFTA negotiations, we have intellectual property rights. And one of the goals of that is to harmonize or coordinate our intellectual property rights systems. So the questions would be, when we have fragmented systems at the intergovernmental and sub-regional levels, which systems would then be prioritized at the continental level? But beyond those two main intergovernmental organizations, we also have regional economic communities that have provisions on intellectual property. So we have the Southern African Development Community, SADC, that has provisions on intellectual property. We have the East African Community that has provisions on intellectual property. We have COMESA that also have provisions on intellectual property.
Are they all different?
Yeah, they're all different. So
okay,
while you have
So I'm not a lawyer, and I'm sure there's at least one other person I can speak for my parents who are not lawyers. So if we just go back to why IP? Like, what's the big deal with IP, and why would everyone have different kind of IP? Like, is it possible to tell us what the difference is and why that matters? Like, if
so we can. Okay, thank you. So we can map intellectual property into different periods. So we could start from the perhaps pre-colonial period where we had open systems of knowledge sharing and open systems of governance. And then we got onto the colonial period where colonial administrators linked their intellectual property systems with their colonies. And then we had the post-colonial period where newly independent states decided to design or introduce new intellectual property systems, and that was tied with the obligations they had at the international level. So while a country in the first place might not see the need for a certain type of intellectual property system, it might have an international obligation, and that would then impose the duty for it to introduce a system. One of the watershed moments for intellectual property in Africa and around the world and global South was in 1995. So 1st of January 1995, with the introduction of the Agreement on Trade-Related Aspects of Intellectual Property Rights, TRIPS. So what TRIPS does is that TRIPS provides global minimum standards of intellectual property rights. And the interesting part about TRIPS was that TRIPS was linked with the World Trade Organization. And the World Trade Organization is a single undertaking. So that means that countries that want to be part of the multilateral trading system and sign up to the World Trade Organization would automatically have to fulfill obligations under the TRIPS agreement. So for African countries, for example, that might have competitive advantages with agriculture and would want to benefit from the agreement on agriculture under the TRIPS, under the WTO, they would still need to be signed up to the TRIPS agreement, because to be a member of the WTO, you have to sign all of the agreements of the WTO. So that link between intellectual property rights and trade under the TRIPS agreement as part of the WTO single undertaking is what changed the landscape of intellectual property rights in Africa.
So could you give us a practical example with either a product or something that can help people actually understand what the issue has been for Africa?
Okay, thank you. So maybe I should take a step back now to just for the members of the audience or people listening that don't perhaps have expertise in intellectual property rights. So intellectual property rights is a broad canvas for different types of rights that cover innovation and creativity. So we could divide it into three main parts: industrial property, copyright and allied rights, and sui generis rights. Industrial property covers patents. So for example, if you have a new invention, a new way of using apps on a mobile phone, you could protect it through a patent. So a patent protects both the product, that's the actual product, the eventual product, or the process. So that's what a patent does. You could have a trademark. So your name, the name of your brand, of your platform, could be patented. So it could be protected under a trademark. You could have a geographical indication. A geographical indication is a mark that protects goods that originate from a particular territory. So there's a link between the territory and the product. And you could also have protection for industrial property, industrial designs, So those are under the label of industrial property. You have copyrights and allied rights. So copyright protects things like books, plays, TV, TV shows. All of those works that come under the creative industry would be protected under copyrights. And then you have sui generis rights. Sui generis rights are simply rights that are unique or of its own kind. One example would be plant variety protection, and that protects new varieties of plants. So those will be the three main headings of intellectual property rights: industrial property, copyright and allied rights, and sui generis rights.
So I have two questions for you. The first is, why don't people actually use IP much in Africa? So I've got my farm is trademarked, and it took, the second question was, why does it take so long? It took me about 8 months to actually get this trademark, and I had an objection from one of the biggest banks in South Africa because I used the zebra. So just two questions. Why don't people use this, and why does it take so long?
So those are great questions. One would be that we need to think about the types of innovation systems that we have in Africa. So remember the TRIPS agreement I mentioned earlier? Mm-hmm. The TRIPS agreement sets the international minimum standards of intellectual property rights. For example, we take patents, which is an industrial property. It says that for you to patent a new product, it has to be new. It has to have industrial applicability. It has to be part of the patentable subject matter. The question would be, do our types of innovation then fit under these requirements for patentability? Do we have any exceptions to include the types of innovation that might be widespread or prevalent around Africa? So, for example, during the with the pandemic, we've had low-cost innovations that have been designed and developed by manufacturers, by producers, by teenagers, young people around the continent. Would their types of innovation be included in patent systems? And that question is one that many governments have to grapple with, because, for example, the 15-year-old young man that produced a system of washing hands without physical contact might not have the financial resources to go register a patent. So do we have other systems that would help community patents? Do we have any other systems that would help that young man to protect his invention? Or is his invention not, is it not an innovation? Should it not be patentable? The other question then we would have, similar to that, would be traditional medicines, for example. So under Article 27 of the TRIPS agreement, you're allowed to protect inventions in all fields of technology. But then we have questions around traditional medicines. How do we characterize it? How do we identify the ingredients of those traditional medicines? Will the traditional health practitioners have the capacity and the resources to file patents for their medicines?
Is this why we're not filing as many patents? Because
those are, yes, because our types of innovation systems might not fit into the mainstream types of innovation systems that we might have in the global north. The requirements for the patentability might be onerous. The financial resources required to patent the products might be above what the low-cost manufacturers or inventors can afford.
How much are we talking about?
I think in different countries have different standards or amounts for application. But even the whole process of going to so for example, in Nigeria, the patent office is in the Federal Capital Territory. If you have a low-cost 15-year-old innovator in a small village in Osun State, for example, he might not even have the resources to fly to Abuja in the first place.
Okay. And do we know how much Africa is losing out on innovation because of we're not patenting our stuff? Do we have any idea of the scale of this?
So we know that the level of registration in Africa is really low compared to other continents. But my question would be that, first of all, we need to also think about our types of knowledge systems. So we know that, for example, for Afronomics law, our platform is open, so it's freely accessible to any subscriber and freely accessible to all readers. And that's part of the ethos of many inventors and creators in Africa. We have knowledge systems of sharing, so our systems are not usually conceived through monopoly rights. We don't think about knowledge as monopoly rights. We think about knowledge as communal rights. So you have a new variety of plant, for example, your immediate thought as a farmer might not be to protect it. Your immediate thought would be to tell your neighbor that, oh, this rice really grew well this season. Do you want to try it? That's free. You're giving it to your neighbor for free. And your neighbor could say, okay, I'm going to help you clear your farmland. That's our type of system of sharing. Or you have a young woman getting married, your aunties can give you a pack of seeds for free. Oh, you could try this in your garden and plant these new varieties of corn, for your family. So our knowledge systems are knowledge systems of sharing in the first place. So our immediate thoughts are not monopoly exclusive rights. But now that we've been integrated into this multilateral system of monopolies and of protecting and of private rights, we then have to think about how we want to engage with those systems. What type of prerequisites do we want to set? What type of standards of protection do we want to set in a way that would then be inclusive of the innovation systems that we have?
That's a really good point, because it's not just about the legal system knowledge, but it's also a cultural one. So how do you get people to think, let me protect my IP, and then you have to pay for it, but we're sharing? What are you finding? What are governments doing about this to try and change that mindset?
So what we have at the moment is we still have systems where, for example, our patent systems, most of the registrations will be from foreign companies. So it'll be from foreign multinationals, foreign companies, and we see that our systems are driven through those external forces. So many times where there's going to be a revision or introduction of the law, it's usually supported by external forces. So for example, for Nigeria, when we're going to introduce the biosafety law, it was driven through foreign multinationals. They were the primary ones interested in introducing the biosafety law, because the biosafety law was necessary for the introduction of genetically manufactured organisms and foods. And those were the companies that were producing those foods. So we have a system of intellectual property rights where our governments, many governments in Africa, do not prioritize intellectual property rights. However, we have developments with these two main intellectual property intergovernmental organizations, and there's a move or a push to promote and disseminate knowledge about intellectual property rights and promote the registration of intellectual property rights around the continent. We also have some support from the World Intellectual Property Organization. So the World Intellectual Property Organization signed a tripartite agreement with OAPI, that's for the French-speaking part, ARIPO, in 2018 to promote intellectual property rights around the continent. But the question then would be, what type of intellectual property rights are we promoting? Are we promoting intellectual property rights that will be for the benefit of foreign multinationals? Or are we going to promote intellectual property rights that will be fit for purpose for the types of inventions and creativity that we have on the continent? So I'll take two examples that I would say that are our strengths or competitive advantages in Africa. One example is traditional knowledge, traditional medicines. That is one of the ways that we can play to our strengths. So we have traditional health practitioners that can look at trees and tell you the components of those trees. They can tell you to drink some leaves or some components from the bark of a tree, and it could cure certain types of diseases or certain types of illnesses. But one of the things, or one of the limitations of those, is that they're usually not documented. So we don't really have it in books, and we can't explain what the ingredients are or what the proportions are. And it's difficult for you to protect that if you don't have it documented. So many times it's usually just passed down from generation to generation. But what we have at the international level now, and even at the national levels, is pushing for the promotion of traditional knowledge. So at the World Intellectual Property Organization, we have an intergovernmental committee on traditional knowledge, folklore, traditional cultural expressions, and it is pushing for the recognition and for the reward of these types of knowledge systems that we have prevalent in the global south, including in Africa. The negotiations around those, the text-based negotiations on traditional knowledge at the WIPO is still ongoing. It's not been decided, it's not been concluded because there are tensions and contestations between the global north and global south. So while many countries in global north do not understand these knowledge systems, these traditional knowledge systems in the global south, so they don't see how effectively to recognize and to reward it.
Yeah, and it's
Because
interesting you say that because you wrote an article on COVID-19, around COVID-19, and Madagascar and the organic. Is this why the reception of Madagascar's cure was lukewarm from the global north because of this lack of knowledge about traditional medicine?
Absolutely. So that would be one of the reasons. So one of the reasons is if you do not understand a system, how would you know how to protect it, or how would you know how to include it within mainstream intellectual property rights protection systems? The other part of it is that we've also had this debate around counter norms. So by that I mean the norms that are not intellectual property rights, but are related to intellectual property rights. So let's stay on this example of traditional medicines, traditional knowledge. We have genetic resources, right? Genetic resources are the base resources for the pharmaceutical products, right? The end products of the medicines that we have created. The countries in the global south are biodiversity rich, and they are mainly the sources of these genetic resources. So used for both medicines and for plants and for food, the food that we eat, the improved varieties of food. So we have the question around accessing those genetic resources. So how do you, when you see a particular variety of potato, or a particular variety of yam or rice in a country in the global south, how do you get access to it? Should you inform the country or the particular community where you want to take those genetic resources from? Should you give them some sort of compensation for the extraction or for the use of those genetic resources? If those genetic resources are then developed into products that are protected as end results, should you give back some benefit sharing to the countries of origin or the sources of origin of those genetic resources? Those debates then moved. So we have this concept of forum shifting in international law, international relations, where if a particular agenda cannot be successfully determined or successfully established in a particular forum, then the actors move to another forum where there is more reception. So what happened was, global south countries could not push for that agenda in the introduction of the TRIPS agreement during the negotiations, during the Uruguay negotiations for the WTO, they then moved to the UN. So we have the Convention on Biological Diversity. And that convention then introduces and recognizes the national sovereignty, that means the rights of countries over their genetic resources.
Oh, wow.
So you have the introduction of access and benefit sharing laws. And some of the fundamental principles of access and benefit sharing are prior informed consent. So that means that if genetic resources are going to be extracted from a particular country, you need the consent of the national government or the national competent authorities in those countries. And then you should also have a form of benefit sharing. So that means if there's going to be commercialization from the use of those genetic resources, particular types of benefit sharing, either monetary or non-monetary, can be paid back to those sources of origin.
Are we seeing that happen?
Yes, so we're seeing that happen. So we have that under the Convention on Biological Diversity. And to make it clearer, we also have the Nagoya Protocol. The Nagoya Protocol on fair and access benefit sharing sets out the practical steps that can be taken to ensure benefit sharing structures. Beyond that, we have the International Treaty on Plant Genetic Resources for Food and Agriculture, and that is under the Food and Agriculture Organization of the United Nations. Some of the fundamental principles from the international treaty is the introduction of farmers' rights. So farmers' rights stands as a counter to plant breeders' rights. So when you have a mainstream system driven by the global north of protection of plant breeders, you also want to recognize farmers. That farmers are the sources of the genetic materials and genetic resources, and their own types of invention, their own types of innovation systems should be recognized and rewarded. And that is what is established in Article 9 of the International Treaty on Plant Genetic Resources for Food and Agriculture. So what we have now in this we could refer to it as a regime complex of international laws. You see that regime complex, you see the TRIPS agreement, which we've already mentioned as part of the WTO. We see the WIPO IGC negotiations under the World Intellectual Property Organization. We see the CBD under the United Nations. We see the International Treaty on Plant Genetic Resources under the FAO. The question would then be, how do you implement all of this provision at the regional, sub-regional, or at the national levels? And that is what global South countries, African countries grapple with. So how do you reconcile all of these provisions in a way that then suits your own social and economic needs and realities? So for Africa, the question, so back to your question around innovation systems, why do we have fewer types of registrations? Because our own types of norms and practices might be better suited to provisions like farmers' rights that I mentioned as part of the FAO, or access and benefit sharing provisions, because we might not be able to produce the end product that would be protected as mainstream pharmaceutical medicine, or as a new variety of rice, but we have the source materials, we have the genetic resources. So those are the ones that our governments, I would argue, should be pushing to protect. Those are the types of intellectual property systems that we have an advantage with, and that we should then be prioritizing in our intellectual property frameworks on the continent. And also connected to that, in terms of traditional knowledge and our types of innovation systems, would be geographical indications. So remember I said at the beginning that geographical indications are products that are related to a particular country or a particular locality. So examples will be argan oil, which many people will be familiar with, from Morocco. So it's made by the Berber women in Morocco. Another example will be rooibos tea from South Africa, which many of us will be familiar with. We have the Zama Macenta coffee from Guinea. We have Oku white honey and Penja pepper from Cameroon. We have a plethora of goods and products that are indigenous to African countries. And those are the types of innovation systems that perhaps we can think of prioritizing and protecting to our benefit. So I would say that if we have effective geographical indication systems, the questions you're having about registration could be resolved by having increased registration of those types of systems. So while we might not be able to make at this moment or at this point, while we might not be able to design the latest, fastest mobile phone, new phone that would perhaps compete with the Apples or the Samsungs, we have these products, these traditional, cultural related products that we can prioritize and protect.
So it's not too late for us to protect rooibos tea, even though
so those are already protected.
Okay.
But we have other types of products around the continent that are related to sources of origin that we can protect. One of the ones I'm really passionate and that I find really interesting is Tet goat meat. So it's a type of goat meat from Mozambique, and it is protected as a geographical indication.
Wow. I can see why Bisi and James said that we need a dedicated show on IP, because it's a world that I think people don't really appreciate, and it's something that really will be a game changer for Africa in terms of supporting innovation, because we don't protect our innovation. We've not been good at it, and the statistics are really underwhelming. So you mentioned, actually, we need to bring Ohio on, but you had mentioned earlier about the negotiations in the Africa Continental Free Trade Area Agreement. Do you want to just quickly, like 1 or 2 minutes, tell us what's going on there? You touched on that briefly, but what's the state of that?
So what we have at the moment is that it's part of the phase 2 of negotiations of the AFCFTA, and the questions that we have from what I said at the beginning around the fragmented systems on intellectual property will still feature there. So the question is, what type of intellectual property system are we going to present under this phase 2 negotiations, or under the intellectual property rights for the AFCFTA? How do we reconcile the different provisions, the existing different provisions that we have? So at the regional level, we have some developments on intellectual property rights. So we have the African model legislation for the protection of local communities, farmers, breeders, and access to biological resources. So that is one living law. That is one example of a way that the African Union has creatively translated the conflicting and competing intellectual property systems at the international level into a living law at the national level, at the regional level, that can be beneficial to Africa. So that is one example that we have at the regional level. We also have the discussions around the Pan-African Intellectual Property Organization, PIPO. But the question with PIPO would still be, how do we reconcile the fragmented systems under OAP and ARIPO? Which of the systems will prevail? So I would say that for the AFCFTA, we need to think about what are our strengths in intellectual property rights in Africa? What types of innovation systems do we want to prioritize? Who are the inventors and the creators that are going to benefit from the intellectual property rights that we introduce? Because I think that this is a moment where we can define what our intellectual property rights architecture would look like. So in the periods or in the previous developments and emergence of intellectual property have been influenced by external pressures. But this is a time where Africa can design a system for its own self and to reflect its own type of innovation and creativity. So we can build on the existing frameworks that we have. I would say that we should prioritize this Africa module law that we have, prioritize farmers' rights, traditional knowledge, geographical indications, and then open up our definitions and requirements for patents, for example, to include the low-cost innovation systems that are prevalent on the continent.
That's fantastic. I think I'm going to read your articles again because I read the COVID-19 one, but it's always great that when you explain the dynamics, because I didn't quite appreciate what the issue was. But thank you so much for talking about IP. We could go on, and we'll probably have to have you on again. But I just wanted to bring Ohio on to talk about contract law. So thank you so much, Titi.
Thank you.
Okay, so I'm going to say hi, Ohio.
Hello.
Hi.
Can
Thank
you
you
hear me
for
better?
coming back on. I know you did your intro before, and then we got caught up in the fantastic conversation on IP. So thank you so much, Titi, for answering my question. And you were going to talk to us about contract law.
Yes. So talking about
Oh,
contract
just
law.
one. Someone asked if you could please turn your volume up because you're a little
Okay.
faint.
Is it any better now? Can you hear
Much
me?
better. Yeah, thanks.
Fantastic. Yeah.
So we're going to talk about the gaps in contract law in Africa.
Oh, okay. Yes. It's I was thinking about it from the perspective of issues that are kind of unique to Africa. And one area that I would want to highlight in the short time I have here is the dispute settlement, systems or processes and the involvement of African practitioners in this space. Because contracts are, I would say, are no use if there are no effective systems for dispute settlement, for resolving disputes. And in that regard, um, commercial arbitration, investment arbitration has become basically a staple. But then we need to ask ourselves, who 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 are the people arbitrating, responsible for settling disputes that involve African parties, that involve contracts that have an African element in international for who are responsible. And the statistics are not very encouraging because it shows, or we see that there's a disparity. Um, in terms of utilization, so we have a lot of commerce going on, and with the AFCFTA, this is bound to increase because at the end of the day, the aim of political actors coming together to put together all these trade deals is to boost intra-African trade. Intra-African trade between who? Entrepreneurs. And when entrepreneurs have interactions, there will be disputes. And when there are disputes, there has to be a way to settle it. And when it comes to settling it, that's a whole industry in itself. I mean, based in the United Kingdom, and I always ask my students one question. I ask them, I say, what's the most important export from the United Kingdom to the rest of the world? And sometimes they go, the English language. I'm like, well, yes, but more importantly, it's the common law, the way, the legal system. And um, taking it back to kind of what Tito was talking about, there is a need to understand that if we do not own or are contributing to the creation of knowledge and the actively engaged in the processes for settling our dispute, then we are already on the losing side, and it will be hard to ever really rise up. And so when I'm looking at contracts, I'm really interested in the numbers. How many Africans or people of African descent do we have practicing as counsels in arbitration proceedings or acting as arbitrators? And I'll tell you the details of the statistics are not encouraging. And also, women are also disenfranchised and also on the losing end. Now, there's been a lot of talk about diversity, and but one very important trend I would want to point out is that, and I think this speaks to what economic law is about also, is that if you leave the um, the actions, that the activities that are needed to make a change to external parties, you will be having progress at snail speed. And so, for instance, there's a lady in SOAS, in the School of Oriental and African Studies in London, Emilia Oyema, and she's been doing some fantastic work in trying to encourage more arbitrators of African descent to get engaged with the arbitration process, and to get themselves noticed, to get themselves on the scene, because it's a very closed circle. It's almost like a club, and breaking in is kind of very frustrating. I remember I did arbitration when I was into doing the masters, and I had these big plans of going on to be an arbitrator. And when I looked through the system, I felt so discouraged that I just gave up that plan. But then I realized that that was a wrong move on my side, because we need more arbitrators, we need more practitioners, and more importantly, we need more scholarship. We need more people talking about these things and bringing up these issues and introducing ways to bring in diversity or force diversity, if I may say. So that's one very important point that I would want to really identify. Then also, when we talk about the arbitration process for settlement of commercial contracts or whatever the case might be, we also see that the hubs where arbitration takes place is very important. Now, this is different from the seat in itself, but the hubs in terms of the centers for arbitration around the world are also a very big um, contribution to the way disputes are settled, but it's also a very big contribution to the economies of countries. The London Court of International Arbitration, for instance, is a very major um, player in terms of the economic activities in the United Kingdom. Now, in Africa, we have a lot of arbitration centers. In fact, we have over 80 when I did my count today.
Really? In 55 countries?
Absolutely. Over 80. I mean, this is statistics from about April this year, over 80. And in that number, you have just about 10 that have international recognition, that are really bringing in the kind of numbers that you would say make it a viable venture. Because remember, arbitration at the end of the day is a private way of settling disputes. And that's one area I feel there is a gap in terms of, and I think it leads back to the question you asked, Titi, why do you have so much fragmentation in
Hmm.
IP space? Why is it that there's this, there's that, so many different models? Now we see the same thing kind of happening in arbitration space. In Nigeria alone, you have 6 centers for of arbitration, and I'm sure that most of them are not really bringing in the cases, or making the right kind of impact. So I think one way or one thing that we need to really look at is trying to find ways to pull together, that community spirit that Titi was talking about. I think it's something we need to start um, making good use of, in being able to get ourselves noticed and get our scholarship and our practice recognized on the international scene. We need to pull together resources, economies of scale. It would really help.
Oh, wow. Okay, so one thing that Titi and I forgot to talk about, and I need to just flash this real quick, is Bisi has reminded us that Oh, sorry, actually, this one. There's actually going to be a webinar on intellectual property rights that's happening. What's the date on this? The
That,
details are on the Twitter handle, but is it the
yeah.
15th?
No, it's on the 13th of July.
13th of July. Okay.
Monday the
Okay.
10th of
So we
July.
forgot to talk about this, but please go to the Twitter handle to get the details of it. And there's a bunch of articles as well that on the website that you can look at. So apologies for that. We forgot to flash that. So thank you for Bisi for reminding us. So okay, so we talked about the gaps in contract law and the many centers. I think that's really fascinating. I think Africa needs to sort of rationalize that. We're sort of running behind schedule. So just wanted to talk about actually your assessment of legal hygiene in Africa. Like, what are we doing right and what are we not doing well? And where are the improvements that can be made?
Absolutely. I would say I'll start with the positives, so that it doesn't just look like we're bashing and bashing. And one of the positives is platforms like economics law. Um, the show that you have here, your project basically is one of the beauties, or should I say, one of the things we need to celebrate about um, the legal regimes and discussions about the legal regimes in Africa. Um, Enhanced visibility. So being on this show, for instance, we've been able to talk. I saw someone comment on the comment section about they felt like being going back to college when Titi was speaking. Yeah. So there's a lot of ignorance. There's a lot of or should I say, lack of quality knowledge out there. Or sometimes the knowledge sharing space is not democratized enough. And so with blogs like this, which are able to churn out very positive and very important information in record speed, cutting down the time of production that you have in normal traditional journals. I would say that knowledge about things that have been hidden gems about the African legal regime, things that are working, are coming to the fore. That's one of the positives I would want to raise. Then also there's something that is kind of gaining a lot of momentum, which we call the Africanization movement. So in international investment law reforms, we have the um, Africanization of international investment law, whereby you have African countries taking, in quote, radical steps to ensure that issues of sustainable development are priority in investment negotiations or for protection of investments with foreigners or foreign countries. Also, we see the same thing even in the arbitration space in relation to commercial arbitration. Now, what do I mean by that? So, for instance, there's this yearly ranking done by some, it's a chambers and partners, where they rate what they call it's called the global rankings of the most sought after international arbitrators in the world. And it's the
Wow.
35 for some reason. And out of the 35 that you have on this list, most of them are of Anglo European descent. Most of them are male. And has been a challenge, and it's a reflection of the problems, or should I say, the lack of visibility of African practitioners. But now, in response to that, the African Arbitration Association, just in June, um, just last month, has introduced what it called a new list of arbitrators of African descent. And on that list, it has presented to the world a list of top practitioners based in America, in Africa, in Europe, that are of African descent that need to be recognized. And I want to add, James Gathii is on that list. I don't know whether they wanted me to mention that, but he's,
Oh, well done, James.
yeah. So, and positive actions like this is one of the things I would say is changing perceptions, because sometimes if you watch the media, especially in this side of the world, you might get the wrong impression that nothing is going right in Africa. But that is not true. And so I would say that in terms of the positives, there is more visibility of scholars and scholarships and practitioners. Now, the things that are not going well and still need improvement, the first one I would say is adherence to due process. Adherence to due process is still a problem. And it may be that there's this conflation or should I say resistance to the way due process is presented to us. So if we don't accept the understanding or the conceptualization of due process as kind of pushed in under conditionalities by as organizations such as the World Bank and IMF, it's difficult sometimes to find it take root. But I feel that one of the key things we need to do to rectify this is that we need to understand that African societies, pre-colonial African societies, were not lawless. And there were ways that things were done orderly. There were processes, there were things that have been doing a lot of research into legal history. And you find out that there are processes, I mean, concepts, things like, Ubuntu that we hear about, and, about that community spirit that Titi also mentioned. Now, these are things that can lend to a reconceptualization or reimagination of due process. Because I think the problem is that if you speak to the people you would class as corrupt politicians, for instance, I think they just don't have the right incentives to do what is right.
That's a good one.
Yeah, if they have the right incentives. I mean, for instance, there's a colleague of mine, Dr. Egosa, who's written about traditional oath taking in the African societies and how it is more potent in dealing with corruption than UN conventions on corruption. Why? Because if you said to someone in an African society that if he or she steals money, that this will be the consequences, well, you might have a different reaction or attitude towards the way public funds are kind of viewed. So I think there are lots of local and indigenous solutions that we have been hidden and lost in our historical past that we can draw on to help to redefine or reimagine this concept of due process. And then we might see that the headlines or the bad or negative headlines will change.
Wow, that's really. I'm so sorry that we don't have a lot of time to explore this, but I think that's really fascinating in terms of that again visibility. The centers is amazing to me. I didn't know we had so many centers, and then also the progress that's made in our history and how we used to do things before we adopted English law and everything else that we're doing. That we actually had law and order. So I think there's a lot that we can explore on this topic, but I'm really worried that we're running out of time. I was thinking I could bring everyone back on, if that's possible, and just get each of you to sort of just final thoughts. Maybe it could be an article that you've written. It could be, the webinar that we were supposed to talk about. So can I bring all of you? So James and BC, just a heads up, I'm going to go off camera because I think people have seen and heard enough of me. I want to bring the Fab Four on to give you their final words on the blog and the amazing work that they're doing. Anything that I forgot? If you've got Facebook in the background, please turn it off because it's going to ruin the sound on the show. So I'm bringing James and BC back on as well. So guys, I'm super excited to have had you on the program. Thank you so much for making the time. I'm going to be following the work that you're doing and support you as much as I can. So we're going to wrap up the show with final words from each of you. It could be, BC, please tell us about the webinar. I'm sorry, we forgot that. It could be an article. It could be something that came to mind as we were doing the interview, but I'll let you guys take it away and I'll close the show after that. James, do you want to get us started?
Okay, so I'll just,
sorry.
Yeah, so first is to say thank you very much to you, Muloongo, and to everyone who joined today on this very interesting and very informative session, even for me, as well. I think the point I want to leave it is that Afronomics law is only 18 months old. It means, we have a lot more to do. And I think this step that we have taken today is only a minimal one. To be able to say sometimes it's important to take a record of where you are and to continue to hold yourself accountable. So I won't see this as an opportunity to talk about an article I've written, but to say that we hope we can count on everyone to continue to build this community and an institution that outlives all of us. And in that process, I want to encourage everyone to see themselves as a legal part of that project.
So I guess I can go next. I joined Bisi in thanking you for having us on. This has been an interesting conversation, and I hope that your viewers have seen both the passion, but also the level of technical details sometimes you can go into, but how connected it is to centering Africa and the Global South in questions of international economic law and economic justice. The one thing that I would add to what we have all said is that we have what we call on the blog an academic forum, which is led by Ohio. And the goal there is to mentor younger scholars who are interested in these issues and who are interested in getting their writing up to speed and getting their nuts and bolts of this system up to speed. So if any of you are interested, once you have subscribed or once you're able to go on the blog, you can contact us. There's an email address there. I believe this is afronomicslaw@gmail.com. And we are delighted to collaborate with anyone that is interested in learning from us or us learning from you. I think it's a two-way traffic. If you look at our COVID-19 symposium, we had about close to 50 published essays from literally around the world, with many law students from Africa as well. And so we encourage you to get in touch with us. We want to provide, as Bisi said, an open platform for engagement both ways, because we also stand on the shoulders of giants that went before us, and we would like to provide the opportunities that we have been able to get to those that want to join this conversation. So thank you very much.
Thank you very much, Muloongo.
Good. Thanks, Titi.
Okay, thank you very much, Muloongo, for this excellent platform. It's very interesting for us to get African voices to talk about the continent from our own perspective. So I would say to all the audio attendees, everyone listening, if you're interested in intellectual property rights, please do join us for our webinar. It's on the 13th of July, and we're going to have very interesting, fascinating discussions around the global regimes of intellectual property rights, the regional realities that we have on the continent in Africa, and some of the developments at the national levels. If you have any questions, any comments, any issues that you'd like us to address, please do send us an email to afronomicslaw@gmail.com. Send comments on our blog post, and we'll be happy to address it during the webinar. It's a pleasure to talk about intellectual property, Afronomics law, and we look forward to further engagements.
Yeah, and they've said it all, but I would just reiterate what James said about the academic forum. That's an area we've created a space where we can nurture interest in international economic law, and we really encourage young scholars. We encourage early career scholars, and even more established scholars, because we are creating a community. And in that community, we would need everyone on board to be able to speak to these issues and provide the necessary mentoring in an informal way. I think one of the key things that you would notice is that we're interested in bringing people up. We're interested in creating that link for the next generation of thinkers, of practitioners, of those who will be activists that will be able to push forward these issues. Thank you so much for having us on the show.
Well, thank you for being here, and thank you to all the viewers for watching this show. Really grateful to the team at afronomicslaw.org, and I hope all of you can subscribe. Thank you for me, Muloongo, and I'll see you next week. Thanks, everyone.
Thank you.
Thank you.
Bye.
Bye.